Hello, this video goes out to Zara, who got in touch on Twitter the other day and requested this topic. But it also goes out to all of my subscribers. I realised the other day that I'm now past 2,000, which is absolutely amazing. So thank you very much to everyone who subscribes. Now, with variation of trust, the starting point is that normally when a trust is formed, that's it, it's set in stone. And the only changes that can be made are changes which are allowed by the trust instrument itself, as we saw in Paul and Paul in 1882. Now, of course, things have changed a lot since 1882, and so there are some, well, actually quite a lot of exceptions to this general rule. So let's have a look through some of those, leading right up to the Variation of Trusts Act 1958. So the starting point for exceptions came in the case of Renew in 1901, where Lord Justice Romer said that the court can allow deviations in emergency situations. However, the interpretation of emergency situations has always been very narrow, and so this isn't particularly helpful. Section 53 of the Trustee Act 1925 allows for variations for the benefit of infants. Section 57 of the same Act allows for deviations in terms of the management or administration of property where it is expedient to do so. And that use of the word expedient is relatively broad, and so the courts do have quite broad powers in relation to the management and administration of property when trying to vary a trust instrument. Couple of other deviations then as well. So for the benefit of those suffering from mental health issues, this comes under section 96 of the Mental Health Act 1983. And finally also for divorce under the Matrimonial Causes Act 1973. And we're looking here at section 24(1)(c) and D. And that's mostly in relation to prenuptial and post-nuptial agreements. So there are a few exceptions then that apply to that rule that we talked about right at the very start, but a lot of these exceptions are sort of interpreted relatively narrowly or only apply in specific situations. And the problem was only exacerbated in 1954 with this case of Chapman and Chapman, which really further limited the variation of trusts by the court down to sort of 4 very narrow situations, which we don't really need to go into, to be honest. All we need to know is that Chapman and Chapman really limited the court's power to vary trusts. So after this case happened, the Law Commission looked at this area of the law and said, right, well, we need to have the courts able to vary trusts in some way, and so we actually need to create a law to allow them to do this. So they came up with the Variation of Trusts Act 1958, which is a very short act. It's only a few sections long, but it's really important. And I think one of the reasons why it's been successful is because it looked at the problem in a slightly different way. Rather than thinking about the different types of trusts that are available, the Act looked at the different types of beneficiaries and sought to protect those particular types of people. So we have the different types of people listed in section 1.1. So 1.1a talks about variations for infants or incapacitated persons. 1.1b, beneficiaries who will receive a benefit in the future or upon some future event. C is for people who have not been born yet. D, people who may become beneficially entitled, but because of fiduciary discretion have not yet been awarded their interest. So we have 4 groups here, and you'll notice that the common theme is that they're all relatively vulnerable and are not able to enforce their own rights. And so we see the types of situations where the courts need to step in and help these people out. So a few more words about the Variation of Trust Act before we finish. Section 1 uses the word arrangement, which gives the court really broad powers in how they can vary trusts. So they have huge scope in terms of how they want to approach things, as long as they are benefiting these vulnerable people. Important thing to say, though, is that they cannot resettle a trust. So we're talking about varying trusts in this lecture. We're talking about deviating trusts slightly, but we're not talking about completely reconstituting or altering the trust completely. If we're talking about that, this goes beyond the variation, and the main case for that would be Van der Velde and IRC from 1967. Other thing to say is that beneficiaries have a right of veto over this. This comes from Goulding and James in 1997. The applicant also is not allowed to benefit themselves from the variation, and this was said by Justice McGarry in Re Holt Settlement Trust in 1969. And the important thing to note here is that when we talk about the applicant benefiting from the variation, it doesn't just mean in terms of like a financial benefit, but it can also go as far as being like a moral benefit. Finally, the variation is done automatically, and so there's no need for other formalities. When we've talked about the formalities in relation to trusts previously, we often talk about the need for there to be writing, for it to be like a deed or something like that. Because we have a court order here that's varying the trusts, there's no need for those formalities. And this was stated in the case of Re Hambledon's Will Trust in 1960 by Justice Wynne Parry. The variation of trust can come up as an essay question or a problem question in the exam. If it comes up as an essay question, you're going to want to talk about the situation before the 1958 Act and how limited the possibility for variation of trust actually was, especially leading up to the case of Chapman and Chapman in 1954. You can then go on in the second half of the essay to talk about how the law has opened up a lot since the Variation of Trust Act 1958. If it comes up as a problem question, you're going to be wanting to think about who is the vulnerable group who will want the trust varied in some sort of way. Now, the important thing to remember is that under section 1.1, that person might not yet have even been born, and so you have to be very careful about who the vulnerable group is, and also who the applicant is as well. And then you can work your way through the Variation of Trust Act 1958. Well, thank you very much for watching this video. If you did enjoy it, remember to leave it a like, subscribe for more videos in the future, and if you have any questions, comments, queries, then leave those in the comments box below and I'll try and get back to you as soon as I can. Thanks very much for watching. Bye!